Well, good afternoon, Michiganders. It is Tuesday, November 24th, almost Thanksgiving, and this, of course, is Tuesday with Tom, Michigan's only weekly internet show where we do our best to answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. Before we get started in today's program, though, a couple important announcements about the availability of the program. We've just been added to iHeartRadio. So if you're an iHeartRadio listener, you can find Tuesday with Tom at your favorite program. Of course, the program is also available on Spreaker. It's available on Apple Podcast, available on Spotify, available on Google Podcast, as well as the Tuesday with Tom website, which is tuesdaywithtom.com. So many more channels available for you to find and enjoy the program. Another announcement about the office. We are finally launching today our legal store at DoyleLawPC.com, where you can simply go to DoyleLawPC.com and order certain documents directly from the website without having to come and see us first, and in many cases without having to even have a telephone consultation with us. So I encourage you, go to DoyleLawPC.com, check out the legal store. We're starting out slow to make sure it works. So initially we're only going to be offering, starting today, certificates of trust. A lot of people have been in contact with us about certificate of trust. They might be selling real estate that their trust involves, or they're settling a trust and they need an updated certificate of trust. You can now go to DoyleLawPC.com, go to the legal store, and order a certificate of trust. Hopefully by the end of the week, if everything comes together, we're going to have some additional documents available too. So a couple important announcements going on, programs available broader, and we are offering more services through our website, including still our Update My Plan service for existing clients and our Planning from Home service, where you can obtain an entire estate plan from home. But let's take a brief review of last week's episode. Last week's episode, I asked the question, will the state of Michigan take your home after you receive Medicaid? I discussed how you can stop the state of Michigan from taking your home after your death if you have received Medicaid. So if Medicaid is something that you're looking at possibly in your future, again, Medicaid being a program essentially for our purposes paying for long-term nursing home care, I encourage you to listen to last week's episode. Today's show, something that happens again frequently in conversations with clients when we look at what they have already done with their estate plan. And today we're going to talk about 3 reasons why to never make accounts jointly owned with a child. But as always, please remember, what I'm about to discuss during the program is for educational purposes only. It is not intended to be legal advice. As always, you need to work with your attorney to determine what is appropriate for you and your estate plan. Three reasons to never make accounts jointly owned with a child. Here's what happens many times. A client decides to make a child a joint owner on her bank account. Normally that's done for one of 2 or both of these reasons, done in order to avoid probate. The client doesn't want the account to have to go through probate. And in many of those cases, that is also done so that the child can pay bills if the client is unable to pay them. So the client goes to the bank, makes the child the joint owner with the bank account, and does in fact accomplish both those goals. Account doesn't have to go through probate, and the child can pay bills if the client isn't able to. But we need to dig deeper because there are certain problems that can happen, and these are problems and basically real life examples. During a lot of the seminars that Amanda and I do, we have a lot of time when we're talking about different topics. Clients will come up to us after the seminar and say, let me tell you what happened to me. Well, let me tell you a couple of those what happened to me stories relative to clients who made joint bank accounts or joint accounts. And one client came up after a seminar and said, I got to tell you what happened. I had some CDs, and I didn't want those CDs to have to go through probate in order for them to go to my daughter when I died. So I went down to the bank and I put my daughter on as a joint owner of the CD. Basically the same thing as making her a joint owner on an account. I put my daughter's name on the CDs as a joint owner, but I was concerned that I did not want my daughter to know I had done that because I was concerned that if my daughter found out that I did it, that perhaps she might, in fact, cash those joint CDs. So I hid them in my house. So I made them jointly owned with my daughter. I hid them so that after my death she would find them, and that's what I did. Fast forward, Mom went on a trip. Mom comes back from her trip. Mom discovers that while she was gone on her trip, daughter found those CDs, obviously in a place Mom expected they would be found after she died, and cashed them. Mom was very distraught because now her daughter had her money, Mom's money, and daughter wasn't willing to give the money back because daughter said, well, you made them jointly owned with me. It must mean you wanted me to have the money. And it was still so striking. The daughter seemed to not genuinely or pretended not to understand why Mom was so upset. Obviously, Mom did not intend her daughter to have her CDs during Mom's lifetime. If she did, she could have just given her the cash. Her intent was part of her estate plan to have those CDs go to her daughter. So what happened? Made the daughter jointly owned on the CDs. What did that mean? The daughter could now cash the CDs, which is exactly what she did. Joint bank accounts, another story, another seminar. Client comes up to her and says, well, let me tell you what happened to me. I made my son a joint owner on my bank account because it was just in case there was an emergency. Maybe I wouldn't be available to pay my bills. I do some traveling. I set up the account just for emergencies. And I made it clear to my son, you're on my account, but it's just for emergencies. And Mom's looking at her bank statement a month or two later, discovering that her son had been withdrawing funds from her bank account. And when she approached her son and said, well, what was the emergency that you were taking the money out of the bank account? It was things like going out to eat, going to the movies, going to the grocery store, putting gas in my car. Not what Mom considered emergencies. Again, what was happening is once Mom made her son a joint owner on her bank account, he had access to her money and was spending it not in the manner that Mom wanted it to be spent. One more story, and then I'll continue on without any further stories. One more story was the client who, in fact, and I've said this at seminars, I say, you make your bank account jointly owned with your child, your child could take your money out of your bank account and go to Hawaii. And everybody in the audience says, oh, not my child, not my child. My child would never do that to me. After a seminar, a client came up and said, that's exactly what happened to her. made an account jointly owned with a child. Child took the money out of the account and left for a vacation in Hawaii. So what's the problem? The problem is that once you make the account jointly owned, your child can take the money. And I know you're going to tell me that you trust your children. And we all want to trust our children. But let me share with you a Money Magazine article that I read several years ago now. Money Magazine, in an article, here's what they did. They went to a group of adult children, and they presented them with this situation. You want to build a house, and you don't have the money to build a house, enough money for the down payment, so you go to your mom, and you say to your mom, Mom, I would like to borrow money from you so that I can build this house. And Mom looked at the child and said, I am going to loan you the money with one stipulation, one condition, and that is, in return for me loaning you the money, you agree that you will never put me in a nursing home. You will make sure for my entire lifetime that you will keep me in my home because I do not want to go to a nursing home. And so these adults were presented with this picture and with this scenario and said, all right, so Mom loans you the money for you to build the house. Fast forward several years later, Mom starts having some health issues, and these adult children were asked, again, in this hypothetical, you received $50,000 to build this home. You agreed with your mom that you would not put her in a nursing home. Mom now has some health issues, and they were asked, how many of you think it would be wrong to now put Mom into a nursing home? Shockingly, only 25% thought it would be wrong. 25% of those children who took the money based upon a promise to their mom that they would never do that, only 25% thought it would be wrong, which means what? 75%, 3/4 of those children in a heartbeat are putting you in a nursing home. So do not trust your children. I say it a little bit tongue-in-cheek, but keep that in mind, okay? Other things happen with our children, and it's your money that we're talking about. It's not your child's money. Maybe they're going to inherit it when you die, if it's left over. Maybe they're going to, but it's your money, and you likely need it during your lifetime. So problem number 1, child can empty your bank account. Problem number 2, what about liability? What about liability? And now we're going to look and say, okay, what if my child is on my bank account and they have a car accident and they get sued? And someone gets a very large judgment against them and is going to collect that judgment from what they own. What do they own? Part of my bank account. Or my child goes through bankruptcy and is a joint owner on my bank account. What do they own that's now going to be involved in that bankruptcy matter? Part of my bank account. Or they're a joint owner on my bank account, and let's say they're going to get divorced one day. And they have to put together a list of things that they own. What do they own? Part of my bank account. Why? Because when I put them on my bank account, I made them an owner. I made them an owner. And as an owner of an account, accounts can be subject to their debts. Accounts that they own can be subject to their debts. Accounts that they own can be subject to their creditors. Accounts that they own might be involved in their divorce or their bankruptcy action. So what did I just do when I made them a joint owner? I potentially exposed my account, or you exposed your account, to liabilities for things you have no control over. You don't control whether or not your child goes bankrupt or gets divorced or has an accident or has creditors or doesn't pay their bills. You don't control any of those things, yet you, when you made them a joint owner or are making them a joint owner on your account or on your CDs, or on your investments or on your real estate. When you're making them joint owner on your property, you are now taking property that is yours and you are subjecting it potentially to their liabilities. I don't think that's a good idea. And a third reason which perhaps overrides all of those reasons or is as significant as doing that, putting your child on your bank account or on your CDs or on your investments might not accomplish the very estate planning goals that you had. And here's what happens. I see it all the time. Amanda sees it all the time. Sees it when we're settling estate. We see it when clients come in and are looking at putting an estate plan together. Normally, there's not just one child. Today, still, most people don't have one child. Most are not only child. There's more than one child. But what did the parent do? I made my one child the owner on my bank account. I made the one child the owner on my investments. I made the one child the owner on my CDs with this understanding that when I die, they will share it. They'll give it to their siblings. They will do what I told them to do. They might even have a will. And their will says, when I die, I want everything to be jointly owned, jointly divided between my children. So I put my one child on my bank account. Guess what? That one child that's on your bank account, that owns your bank account when you die, it is owned by that one child. It is theirs. It is not controlled by your will. It is theirs, and it is theirs to do with what they're going to do. That means what? They don't have to share it with the other children. They don't have to share it with their siblings, and quite frankly, there's nothing the siblings can do about that if they choose not to share it. But they always have to make the child the good child. And the child has every intent of taking this bank account after you die and sharing it with their siblings. But guess what you did not account for in that picture? Your child dying before they have an opportunity to share it. Now what happens? Well, guess what? It is now part of their estate, your son's estate, your daughter's estate. And it will go where their estate goes, which might, quite frankly, not be the same place that your estate is going. They might be married, and their estate is likely going to go to their spouse. Or they might have children, and their estate is likely going to go to their children, which means when you made them the joint owner on the bank account, if they die before they even have a chance to do what you wanted them to do, your estate planning goals have not been accomplished. Another reason that your estate planning goals might not be accomplished, or another consideration, I guess, relative to estate planning goals. It's not that they won't be accomplished, but there's another consideration here that we really have to think about too. And let's say the child does what you want them to do. You've got a bank account, you've got an investment account, you've got some CDs, maybe you've got real estate and it's jointly owned with one child, and one child takes those assets and now is going to do what you want them to do after you have died. Have you considered the possible gift tax consequence to that child? Why? Because that child is no longer giving your money. This is not an inheritance to the other children that could be tax-free. This is now a gift from your child to their siblings. And gifts can have tax consequences to them. Today, in 2020, $15,000 is the annual gift limit before we at least have to start having a discussion about potential gift tax consequences to the child. So when they do what you wanted them to do, they might be incurring a gift tax. So it can be disadvantageous for them to not do what you wanted them to do. Real estate. Let's sidetrack 1 second because this is really about joint owner on bank accounts. But real estate, I've had other episodes of this program, and Amanda and I talk about our seminars. Joint ownership with real estate has an additional problem with it, and that is now you can't even sell it without the child's agreement. If you make a bank account jointly owned with them, you can still take your money out of the bank. But if you make your real estate jointly owned with your child, now you can't sell it without their approval. So you lose control over it. Again, it still has liabilities, still has potential gift taxes, etc. But real estate is even, in many cases, worse than the joint bank account. Now, there's a saying, I get it, never say never. Never make a child a joint owner on a bank account. But what you need to understand are the risks. What is the risk if I put my child on my bank account? And am I willing to take that risk? Are there other options to accomplish that goal? Well, let's take that option about having a child be able to write checks for my bank account. You can have an authorized person on your bank account to sign checks who doesn't own the bank account, who will not inherit the bank account when you die. In fact, when you die, the account is still part of your estate and is not going to be owned by them. That is an option if you're really concerned about being able to write checks on the account. Most of the time, it's not a concern. It's not a concern if you die that somebody has to be able to get your money right away and has to be able to go pay your bills right away. So that concern that they need to have access to the funds right now normally isn't there when you die. But what if you become incapacitated? Your concern is, geez, if I'm incapacitated, I want my bills to be paid. Well, that's exactly why you should have a durable power of attorney. A durable power of attorney giving somebody the authority to handle your finances if you're incapacitated. But the difference is, since they're not a joint owner on the account, and they only have the authority under the durable power of attorney, Michigan law holds them accountable if they violate the terms of the power of attorney. If they violate it and do something that's in their own interest and not your interest. So if your durable power of attorney takes your money and goes to Hawaii, you have something legally you can do about that if you choose to do so, because they have violated the terms of the power of attorney. So there's an option there. If you're concerned about somebody having the ability to pay your bills, manage your finances, if you become incapacitated, you have the option to have a durable power of attorney, which, quite frankly, everybody should have one of those. Everybody should have one of those to make sure that things will be taken care of if they're incapacitated. Having a will. If you want your estate to go to all of the children equally when you die, rather than giving it to one and counting on that one divvying it up, have a will. And don't put your child on the account. Have a will. And the will says that the estate gets divided between all my children. And if that child who's in charge of settling your estate doesn't do what the will says, they can be held accountable. So you're creating a structure of accountability that you do not have if you simply make the child a joint owner on your account. Another consideration, as you probably know, a will doesn't avoid probate. Maybe your plan was to avoid probate, which was exactly in the beginning of this discussion why mom did what she did. Then maybe you should have a living trust. A living trust can avoid probate. A living trust can divide the estate between your children. And as importantly, though, the trustee can be held accountable. So if the trustee doesn't divide the estate between the children as the trust requires, they can be held accountable. So we're trying to create a structure of accountability to assure you that, in fact, that child is going to do what you want them to do. You're not going to be allowing that child to be part of that 75% that's going to totally ignore what your agreement was and do whatever they wanted to do. They will be held accountable. There's a structure in place that will enable others to hold them accountable if they don't do what they're doing. Another consideration. What do you have? What can you afford to lose? Maybe you have a bank account. There's not much money in the bank account. You don't keep much money in the bank account. And you're saying, hey, Tom, if my child took all my money out of this bank account tomorrow, I won't miss a beat. I'll still be able to pay my bills. I might not be happy about it, but I won't miss a beat. And so I'm not going to worry about it. Well, okay, just don't keep a lot in that account then. Maybe you're going to have that account set up so that your child can pay your bills. Well, you don't need to keep $200,000 in your checking account or your savings account in order for them to pay your bills. Just keep an amount in there that they'll be able to pay your bills, and don't make the other accounts jointly owned with them. So you can look and say, it's not all or nothing. When you look at your various accounts, when you look at what you're trying to accomplish and your estate planning goals and your children and who they are and who you trust and who you don't trust, what concerns that you have, what about spouses of your children, what influence are they going to have on a child, etc., etc. It's not all or nothing. So while I started this discussion trying to give 3 reasons to never make accounts jointly owned with a child, I know never say never. I understand that. But you need to understand the risk. You simply need to understand what you're doing. So don't just go ahead and say, hey, I'm going to make my daughter a joint owner on my bank account because I want to avoid probate and I want her to pay my bills. Think about the consequences. Think about the risks. Ask yourself, are there other ways to accomplish those goals? Are there other ways to accomplish the goals where my daughter can pay my bills, where my daughter can receive the assets or my children can receive the assets without them having to go probate? And there are. So look at all of the options before you simply go down and make your child a joint owner. So let's say you listen to this program and you say, you know what? I already made my daughter a joint owner and my son a joint owner. I want to undo that. What you're likely going to find, unfortunately, is when you go to the bank and you say to the bank, I've got a bank account, my son is a joint owner, I don't want my son to be a joint owner anymore. What you're oftentimes going to find that bank saying to you is, I'm sorry, they have to come in and agree to it. They're a joint owner on the account, just like you. Well, but it was my money I put in the account. They don't care. The joint owners on the account are the only ones that can close that joint account. And clients will come back to and say, I went to the bank and the bank told me I can't, so I'm stuck. No. The short answer is, well, set up a new account in just your name. Take out all of the assets from the joint account. If your child can take them out, you can take them out. Take them out and put them into the new account. So don't get stuck with a bank who says you have to have a joint owner come in and take this in order to close this account, because if it's truly a joint account, just take your money back out. Cash your CDs, take your money out, close out your investment account, whatever it takes, close that account out, take the proceeds back, and open up a new account. So there are normally solutions available, even for those of you who've already done what it is we're suggesting today is not a good idea. Well, that is it for today's Tuesday, November 24 episode. But before we leave, just a reminder, of course, that Amanda and I would be honored to have the opportunity to assist you in protecting your loved ones by putting together an estate plan, or perhaps amending a plan that you already have, or assisting you in settling estate. And because of COVID, the office still isn't open. We're not currently seeing clients. We don't want to risk the health of our clients. We don't want to risk our own health. So we do have our planning from home service. Simply go to the website, doylelawpc.com, and there you will get information on how it is that we can assist you in putting together your estate plan from the security and comfort of your own home. Gives all the steps that will be followed in doing that, including a telephone consultations rather than in-person consultations to do that. If you're an existing client, we have our virtual office at the website again, and included in there is my Update My Plan service. So if you're an existing DoyleLawPC.client and you want your estate plan to be updated, we give you an opportunity to do that online as well, again, from your home. So we would be honored, we would be delighted to assist you, and we've put together the structure that allows us to do that and to service you even during this time of COVID. As always, if you have a comment about the program, a topic that you'd like to have me discuss, or questions that you'd like to have answered, please send me an email, tom@tuesdaywithtom.com. Mail me a postcard, Tom Doyle, P.O. Box 16066, Lansing, Michigan 48901. And as always, we invite you to follow us on Facebook and Twitter. That would be Tuesday with Tom. Follow the office as well, Doyle Law PC. Invite your friends and family to do so. We provide a lot of information, current information, some fun information, educational information, estate planning, estate settlement information. All of those available are provided through Facebook and Twitter. Remember, too, that not only is Tuesday with Tom now available, as I said at the beginning of the program, through iHeartRadio and Spreaker and Apple Podcast and Spotify and Google Podcast, as well as the office website, but you can also download from the App Store, download from Google Play the Tuesday with Tom app, so you can take the program with you. And in addition to all of that, you will likely find that you can listen to us on your smart speaker. So if you have perhaps Alexa, you can ask Alexa to play Tuesday with Tom as an example. Well, thank you again for spending some of your time with us on this Tuesday afternoon. As always, I hope that you have an awesome day and an awesome week and an awesome Thanksgiving. Thanks again for spending your time with us, and stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.